Good morning, everybody. I am Haribabu, an advocate at High Court for the state of Telangana at Hyderabad. Indian Constitution is not only the largest written constitution in the world, but it is also the best constitution in the world, but it has been sullied on the same scale by the Indians. Today, let us discuss Article 20, 21 and 22 which relate to protection of life and liberty of the citizens. But let us see how these sections have protected the fundamental rights of the citizens, or how freely fundamental rights have been violated. Bharatiya Nyaya Sanhita classifies offences as cognizable and non-cognizable. They are contained in section 2N and section 2O. Cognizable offences are serious offences, usually attracting punishment of 3 years and more. In these cases, police have right to arrest the accused without warrant from the court. Whereas non-cognizable offences are small offences which usually attract punishment less than 3 years. In these cases, police are not supposed to arrest the accused without warrant from the court. The police shall not arrest the accused where the punishment is 7 years or below without the permission of without a warrant from the court. Police can arrest only where the prescribed punishment is more than 7 years. But unfortunately, the measure prescribed by the Honorable Supreme Court is also being misused by the police. In case where they want to make settlements in civil matters, maybe matrimonial or land issues, they are invoking such sections which attract punishment for more than 7 years. In section 35, police can have custody of the accused for 24 hours, and on production before the court can extend police custody. Thereafter, then can be judicial custody up to 60 days, including the 15 days of police custody. However, this can be extended in suitable and necessary cases by the honorable courts. The purpose of arrest is to prevent the person from doing further crime or to flee the jurisdiction of the honorable courts, or he may meddle with the process of investigation by influencing the evidences. Cases only they can arrest. Otherwise, they have to issue notice to furnish the evidences, etc. to the accused. Despite these so many safeguards in the law and as per the judgments of the honorable courts, still human rights are freely violated. As per an estimate, as on date, about 5 lakh people are aging in jails as under trials. It is unfortunate why a person should be imprisoned when the person is known, his address is known, all his contacts are known. Can't the police prevent him from further perpetrating the same crime? Can't the police stop him from escaping from the clutches of law? Can't the police prevent him from influencing the witnesses? So this is the inefficiency of the police which ultimately is resulting in imprisonment of citizens. Imprisonment is the worst form of violation of individual freedom. Even MLAs, ministers are imprisoned indefinitely. Where do they flee away? Having known him to be a perpetrator of a crime, can't the police keep a watch on him? So moreover, even after arresting and imprisoning for a long time, in most of the cases, these people get discharged, acquitted. Then would his respect return back to him? His prospects in the politics and business, he will lose. And sometimes it happened in the case of a woman also. So police and investigating agencies must be more vigilant, more active, instead of keeping people in prisons. At this juncture, I would also like to bring to the notice of the listeners how the Indian justice is plagued by delays. If a civil suit is properly conducted, right from magistrate level to the Supreme Court, I do not think a civil case can be finalized during the lifetime of a person. There is a fault in the system. For delays, we cannot question the courts. There is no mechanism to question the courts. But they will say that the number of courts are less in India compared to developed nations. My question is, why should you compare with developed nations? If anything is not developed, should this legal system and courts only should be developed? When you ask legal experts, they say that judges are sometimes lackadaisical. They grant adjournments very liberally. Of course, there is deluge of cases, I don't deny that. It does not mean that there should not be good practices. As per an estimate, there are about 5 crores cases pending in Indian courts. If I take 5 people on either side of a case, there will be 10 people on both sides. And in 5 crore cases, there will be 50 crore people involved. Even estimating 50% of the cases relate to governments. Even then, 30-40 crore people of this country are waiting for justice to be done to them. It is by no standards a less number. Definitely something has to be done in this regard. And again, coming to the facilities in courts, who come to courts are not only criminals. Very gentlemen, respectable people. For their financial transactions, partitions, or affidavits, or for some other purpose, they come to courts. They don't have any place to sit. They don't have any amenities. This is most unfortunate. People actually are feeling insulted. It is after all for the purpose of the people that the courts are established. Courts are established not to give employment to judges, nor livelihood to advocates. There is no protection of law for the citizens. Supposing I have given my house on rent to somebody through a registered lease deed for 5 years. So today itself he knows when he is required to vacate the house. But surprisingly, after 5 years, when I ask him to vacate, he would say that he is not getting suitable accommodation elsewhere, and hence he cannot vacate. It is a breach of trust and cheating. Believing on your covenants, I handed over my valuable property to you. And after 5 years, you denied to pay even the rent also. I am not living on any salary from the government, nor am I getting any pension. The only livelihood is my rent from the house which I have built during my younger life, saving, restricting all my needs. Today, that property is occupied by somebody who doesn't pay rent. If I go to courts, the courts may ask him whether he is a tenant or not, whether a tenant and landlord relationship is subsisting or not. If such relationship is existing, the courts can simply ask him one question on the very first day itself. How much time do you want to vacate? He has to stick on to that. A reasonable time may be granted. If he doesn't do that, the court should order him to vacate. So also in money suits, the debtor says, I have not taken money. Then why did you sign this promissory note? He will say, no, I have not signed this promissory note. This is not my signature. No, you have taken money from this man for the marriage of your daughter, or for construction of your house, or for paying a fees, etc. I don't know this gentleman. Neither I know him, nor I took any money from him, nor the signature is mine. This will run for several years. That way, please understand, people of this country are losing faith in the judiciary. In the sense, they may not get justice in due course of time. What after all is the effective lifetime of a person? If I go around the courts for 10 years, 10 years from my effective life is too much for me to lose. In criminal matters, sometimes there may be a punishment prescribed of 3 months, 4 months, or 6 months. But whereas to decide that, he will be made to go round the courts for about at least 5 years. All these 5 years is a punishment worse than imprisonment. He will lose his livelihood and other important works. He will lose respect in the society. He will be mentally sick and may even die emaciated. This is purely inhuman and injustice. The judiciary, the legal fraternity, and the governments have to think about it. Thank you for watching my video. Please subscribe, share and comment on my videos, and I will be thankful. Thank you.